When it comes to security deposits, even the most diligent property managers can get sued. Do some due diligence to try and keep from going to court over items that could have been resolved earlier. I'm Kim Meredith Hampton, a property manager with Hampton & Hampton Management and Leasing, Inc. in Orlando. Let's take 5 minutes to talk about how to minimize the risk of a security deposit dispute. First, as a property manager, you should know the laws. Properly classifying and depositing the security deposit in the beginning, along with communications, documentation, and a solid system, can help you avoid disputes. Remember, the security deposit does not belong to the landlord. You are holding it on behalf of the tenants during their occupancy. Classify the security deposit as just that, and do not accept it as the tenant's last month of rent. If you use the deposit as the last month's rent, how do you know the tenant will not trash the property or cause other damages? Next, the security deposit should be held in a separate, non-interest-bearing account until the end of the lease, and then returned to the tenant if there are no damages. Never commingle these funds with your personal funds. Florida law prohibits landlords from commingling funds. It's a good idea to have an escrow account separate from your corporate or trust account. This makes the reconciliation process so much easier on a monthly basis. In addition, I'd like to take photos and video of the property before the move-in so that I can compare them to the photos and video after the tenant moves out. I've found that I can reduce disputes by sending the tenant a move-out requirements list as soon as they have given notice to vacate. This list should include expectations for cleaning, carpet cleaning, painting, lawn, AC filters, keys, and a forwarding address, among other things. Once the tenants vacate, you'll need to perform the inspection and assess if there are any damages. You can also hire a third-party inspector to perform the move-out inspection. These inspectors are neutral and are generally very thorough. They provide tons of pictures and a written report. When it comes to returning the security deposit, the Florida deadline is 15 days from the date they vacate. If you intend on giving back all of their security deposit, you need to deduct any monies from the security deposit within 30 days from the date they vacate. You must provide an itemized written deduction list sent by certified mail to the tenant's last known address. It's a good idea to include receipts or estimates with their claim. After all that, what if you still have a dispute? I have a property management friend who offers a secondary review of security deposit disputes. This ensures a fair distribution of the security deposit between the landlord and the tenant. She then has a review committee that objectively reviews all information, including the tenant's comments or evidence, solicits additional information from the landlord, and in some cases the tenant, then makes the appropriate adjustments. The committee also performs this service within a reasonable time frame. Nobody wants to go to court or keep someone's money unnecessarily. Try and work out a compromise. If needed, seek the help of a mediation company. There are many that are located throughout the state of Florida. If you weren't able to compromise, and sometimes that happens, and you must defend yourself in court, please make sure that you're prepared with the following items: a copy of the lease agreement, any move-in or move-out pictures or videos, a copy of the tenant security deposit claim, and copies of any receipts, invoices, or estimates. You also may want to have a witness to testify against anything that was missing or damaged. Be detail-oriented, document, and communicate. Those actions go a long way toward avoiding security deposit disputes. However, if you're careful, detailed, and have a system in place from the acceptance of the security deposit, you should be able to keep your disputes to a minimum. Good luck.